Why would Congress want to treat federal and state prisoners different? Why would Congress want to treat state and federal prisoners different? Why would they, Mr. Adler? Well, Justice Thomas, the short answer is federalism. We know throughout AEDPA that Congress did in fact treat state and federal prisoners differently. We cited numerous examples in the statutory text that reflects that differential treatment. And we even see that with respect to second or successive applications, as well with respect to the newly discovered evidence criteria, which we know are different. The fact is that state prisoners, when they are in federal court and challenging a state judgment, that the tension is high with the sovereignty of a state court. And so that is why we see it with exhaustion. We see it with the deferential standard in 2254D. We see it with the limitations on evidentiary hearings, and B1 is just another example of that differential treatment. So what was the point? What was Congress trying to accomplish with 2255 with the addition of H in 2255? In H, Congress was enumerating the two conditions that federal prisoners must, one of two conditions that they must satisfy before they can bring a second or successive 2255 motion. The only other thing it did in H was incorporate the certification provisions in 2244B3 that govern how the determination is going to be made. As between federal and state, beyond the federalism issue, why would those be treated differently? The prisoners, the federal prisoners and the state prisoners, they had been treated differently. But I think the effort by Congress was to bring them closer together in treatment. Your Honor, we don't agree with that. We see numerous examples in AEDPA where they're treated differently. So we know that they're not treated the same. And beyond federalism, we know finality concerns are different. State prisoners have had multiple rounds of review by the time they get to a successive 2255 for petition in, and the number of state prisoners far outnumber federal prison in our systems. And so Congress would have been concerned about finality most of all with state prisoners, including the fact that the vast majority of capital inmates here in this country are state prisoners. Going back to that point, when you say multiple rounds, a state prisoner has had a state court, intermediate state court, final Supreme Court, a district court, and a court of appeals. But in federal court, a prisoner only has 2 rounds or 3 rounds of review, correct? That's correct. What state prisoners have that federal prisoners do not is that they also have state post-conviction review, which serves as an additional level of review that federal prisoners do not have. They also have, of course, the right to appeal any federal claim to this court, even on direct appeal of their state conviction. And we actually see a collateral estoppel bar in 2244C that applies only to state prisoners. Mr. Counsel, I'm sorry, no, please, Counsel, I don't want you to give up your first argument on jurisdiction. I know that in a previous statement I made in this very case, I suggested that it was wrong, but your brief gave me great pause. Don't give up on it, all right? Your position is that the cross-reference barring jurisdiction does not unambiguously incorporate the cert bar that exists for state prisoners, correct? That's correct. And our case law is replete that to deprive us of jurisdiction, it has to be clear. That's correct, all right, and unambiguous, correct, and this is not, all it says is that the successive habeas motions filed by federal prisoners must be certified as provided in Section 2244 by a panel of the appropriate Court of Appeals, right? Correct. So ultimately, what is your point, Mr. Chief Justice? And if it pleases the court, by its plain terms, 2244B1 applies to habeas corpus applications under Section 2254. It therefore does not apply to motions to vacate under Section 2255. After all, those motions have their own separate gatekeeping requirements. Resisting this straightforward conclusion, The court-appointed amicus proposes an elaborate theory that no court in the country has adopted, but the plain text, context, and structure of the statute make clear that B1 does not apply to federal prisoners. This court has jurisdiction to so hold. We have offered several arguments for why 2244B3E does not bar review here, but the simplest one is this. The subject of our cert petition was not the denial of an authorization. This argument is based on Castro and the passage on page 380 that starts with the sentence, even if, for argument's sake, the court assumed that there was a denial of an authorization because the Court of Appeals had stated that the prisoner could not satisfy the gatekeeping requirements, but this court unanimously held that this denial was not the subject of the cert petition because the prisoner sought review only on the antecedent question of whether he had to satisfy the gatekeeping requirements at all. There is no material distinction between that question reviewed in Castro and the question here, which is whether petitioner must satisfy the gatekeeping requirement in B1 at all. What in the hell are we talking about here? Let's get all the way down to right here. No, let's start with right here. Mr. Chief Justice, and may it please the court. Section 2255H incorporates the certification process for second or successive applications in 2244B3 and B4, and because B3E prohibits review by petition for a writ of certiorari, this court lacks jurisdiction. 2255H specifies three key aspects for certifying a successive application: who must certify it, what is certified, and how that process proceeds and stops. First, certification must be by a panel of the appropriate Court of Appeals. Second, the application must be certified to contain either of H1 or H2's content requirements for new evidence or new rule of constitutional law. And third, the application must be certified as provided in Section 2244, which means the certification process proceeds in the same manner as in 2244. B3 and B4 are the only provisions in Section 2244 that address the certification process for authorization, the filing of a success. Jesus Christ. When I tried a version of that argument to Mr. Adler told me that I was just adding the word process, which no place appears in the statute. Well, and of course he's right about that. Process doesn't appear, but it says certified as provided in Section 2244, as provided by the Court of Appeals. So that would suggest that even though it looks a little bit weird to go from A to D and skip E, what 2255H describes is the stuff that's described in A through D, but not in E, Mr. Yang. But that's just part of the analysis. You also have to look at the language in E. E uses second or successive application, and it talks about the authorization second or successive application. If Congress had intended to include to cut out state prisoners, it would have done exactly what it did in B1 and B2. It would have said second or successive habeas corpus application under Section 2254. Instead, B3 and B4, which are all procedural provisions regarding the process, which we think is incorporated, all use distinct language. And no one has come up with any explanation that will respond to the Russello presumption. It's a strong presumption. All these provisions were enacted at the same time. Don't forget about the Russello presumption. Could you comment on Mr. Adler points to this language from Castro, which is about this very provision, of course, and it says, read one way, it would close our doors to a class of habeas petitioners seeking review without any clear indication that such was Congress's intent, indicating that a clear indication is what's needed, given the basic principle that we read limitations on our jurisdiction too narrowly. No, I don't want to comment on that. Do you comes from, and that's all. Do you think there's a clear statement rule or not? I think no. At least not broad, as broadly defined. If you look at, what does that mean? If you look at what Castro cites, it cites two for the clear statement, Utah versus Evans. You think there should be a clear statement rule, add that in two? No. What the fuck? What is this case? What are we even talking about in this case? Bowe v. U.S. Michael Bowe v. U.S. 245438.